Hi everyone, Armine Bazikian from Bazikian Law Group. This month I want to talk to you about a very important law change that is taking place on February 16th in California, and you all voted on this issue. Proposition 19 changed property taxes in California. So this is the new law change. We're going to go into the details. I want to give you guys information on what the current law is, what the new change is, and how it's going to affect you. So Proposition 19 dealt with property tax assessment basis. So basically the amount of property taxes that people pay. So with the new law change, before we actually dive in, let's take a step back and talk about what the current law is. So property tax basis transfers are allowed between a parent and a child and a grandparent and a grandchild. So essentially what that means is that as a parent, you can give your kids property that you own without the kids actually seeing any changes on the property tax, which meant that the property taxes can stay exactly the same without there being any changes on it. So what this actually means is that mom and dad can give their home, their primary residence, to their children, and the children would continue paying whatever property tax mom and dad had been paying for 20, 30 years and move on with life. The current law also allowed the children to use that property for whatever they wanted. So they could use it as a rental property, they can use it as a vacation home. And the current law also allowed parents to transfer not only their primary residence, but also up to $1 million base value of other property that they had. So that's the current law, meaning mom and dad can transfer not only their primary home to their kids, but also, that rental property they had or that commercial property they had, up to $1 million each parent. So technically, as a couple, parents can transfer up to $2 million in property tax basis to their kids in rental or investment properties. So let's dive into what the new law changes are and what it means for you guys. So with the new law change, one of the most significant things that changed is a restriction on what the child can actually use the residence for. So previously, it didn't matter that the child used it as a residence, vacation home, or rental property, but now it does. So effective February 16th, the children have to use the property as a primary principal residence. So this is a significant change. So it doesn't work out too well in real life. For example, if mom and dad pass away, or let's say they haven't passed away, they just want to transfer their residence to their child, the child has to move into that property and use it as their principal residence. So you can already see that this will create some issues for people in the future when their parents are gone, because they'll have to move into their old family home, and it'll create additional problems if there's multiple siblings inheriting a property. The question is, do all of them have to move in? It's not very clear as of right now. So that's one of the actual changes, is the use of the transferee and what it is that they're going to be using the property for. It's limited to only residential. The second very significant portion of this law change is that previously parents can transfer the property and it didn't matter what their tax basis was. So they could have bought a $2 million property, lived in it for 20 years, and then gave it to their kids, and their kids would inherit with the $2 million property tax basis. Well, now that unlimited number that the parents were able to transfer for their residence has been eliminated, and now they are restricted and only limited to a $1 million exclusion, which means only $1 million of assessed base year value can be transferred to the child. So this is a significant restriction, as you can see. The third very most important law change here that's going to affect a lot of individuals out there who have investment properties, you will no longer be able to transfer the investment property tax basis to your children. So previously the law said that you can transfer up to $1 million individually to your child. Well, you can no longer transfer any non-residential property and keep the property tax basis the same. So this is significant because we have lots of clients who own multiple properties in addition to their residentials, and they purchased them years and years ago, so their tax bases are very low. And I'll illustrate this with an example. Let's say mom and dad have a house they bought for $500,000, and they also have 2 rental properties. that they also purchased for $500,000 each. So their property tax base valuation for each of those properties is $500,000. That's the magic number. When mom and dad are gone and they want to transfer all three of those properties to the kids, under the new law, they will be able to transfer their home to the kids at their death without the kids seeing any property tax changes, which means the kids will continue to pay whatever the parents were paying in property tax changes as long as they use that property for their primary residence. And then the other two investment rental properties that mom and dad had can be transferred to the kids, but as soon as that transfer happens, property taxes will be reassessed to the date of transfer or date of death value, which means that if those properties are now worth $2-3 million, the kids are going to be paying property taxes on that valuation, $2-3 million, not the $500,000 that we were previously able to transfer under the old law. So this is a huge change for real estate investors and real estate owners. It's a significant blow to basically the middle class who owns maybe one home and one rental property. So I really urge you guys to look into this law change. And don't forget, this does not just apply at death, it can also apply during life transfers. So if you have investment property that you would like to transfer to your children during your life just to be able to keep this property tax basis, I would highly recommend that you do it before February 16th. This new law change takes effect February 16th of 2021, so I really urge you to do it. It also restricts the amount of time that you have to file for the claim from 3 years to 1 year, so be cognizant of that.